Hi everyone, Dave Sugden of Evidence at Trial. Today, we're going to talk about how to apply the business records exception to certain types of documents. In a prior video, we talked about the business record exception itself. What are the elements? How to apply it? What we're going to do today is look at certain types of documents that often come up but can trip up lawyers, and let's talk about how to apply them. We're going to talk about three specific types of documents: third-party records, medical records, and investigative reports. Let's first talk about third-party records, okay? And so these are documents oftentimes when we're the proponent of a business record, what we're talking about are oftentimes our own client's documents or documents by a third party where we can talk with that third party, talk to a custodian or qualified witness who can attest to all of the necessary elements to establish a business record. But what about the occasion in cases where we have a third-party record, an invoice, for example, but no witness? Can these be used? And let's assume that our client, for example, received the invoice, paid for the invoice. It seems like a trustworthy, reliable document. It should be admitted. If that's what our intuition is, we're right. But there are certain limitations. And to understand the limitations, the case to look at is Pacific Gas and Electric versus Thomas G.W. Dryage. And what it talks about is a case where the plaintiff had these third-party documents and there were invoices for repairs. And the plaintiff was suing the defendant saying, hey, you caused this property damage. I've now had to incur these costs. I paid for them. And I want to introduce these records. And they were introduced during trial. And on review, what the court did is look at how were these documents actually used. And they were used for three reasons. One, to show that invoices were paid. Two, the plaintiff wanted to show that the invoice price itself was reasonable. And the third reason is that the repairs were actually made. And what the Supreme Court of California said is, look, these documents without a custodian talking about it being a business record can independently prove nothing. But what they can do is they can provide corroborating testimony. And so, for example, in that case, what the plaintiff testified to is, look, I received these invoices. And in fact, I paid these invoices. And here are the invoices. And what the court said is, fine. For the purpose of corroborating that the invoices were actually paid, those documents can be admissible. The next thing is the plaintiff said, and by the way, because I paid them, they must be reasonable. And what the court did is it cited a case called Imperial Cattle versus Imperial Irrigation. And what that case says is that when a party receives an invoice, it has every incentive to dispute it, discuss it, raise an issue if it's too high. And so the fact that the plaintiff said, I received this, I paid this, the invoice can be evidence that the price was actually reasonable. But what about the fact that the repairs were actually made? What the court said is, no, you can't just have a record without a custodian attesting to what was done, the plaintiff not attesting to what is done, and use that to prove it. And so what the court said is, no, for that purpose, you can't prove it. And so what the plaintiff should have done is used it, just like the evidence that they actually paid the invoice, as corroborating evidence. What the plaintiff could have done is said, these are the repairs, have some witness who can say, I saw the repairs, they were made. These invoices reflect what was done, and it becomes corroborating evidence. And so you see, without that custodian or qualified witness attesting to the elements of the business record, the use is limited. Let's now talk about medical records. Now, medical records often come up in cases, and when you think about medical records, what you want to do is look specifically at why the records are being used. A good example is in the case of People versus Williams. This was a criminal case, and it involved a murder that was fairly grisly. And the defendant's defense was he didn't commit these acts, but rather it was the decedent who had too much to drink and fell, and that's what caused the death. It wasn't a homicide. What the defendant wanted to do is get all of these medical records and introduce evidence where this decedent had lots of occasions where she would relay to medical providers that she drank too much, that she would fall down, that she would fall over. And so could these be admitted? When you think of medical records, a good way to think of it is pretend the record itself is the doctor on the stand testifying. Because it's a great way to spot what would be allowable in the record into evidence versus inadmissible hearsay. And so, for example, what the court said in Williams is that everything that the doctor observed, that was allowable as a business record, because the doctor's saying, I saw this person and this is what I observed, and it's his observations. Again, looking at the elements of a business record, he's recording something at or near the time it happens. But the moment the decedent said, she said, what happened? For example, she says, I drank too much, I fell over, and he's writing that down. Now we're talking about hearsay. Is it admissible? In this case, it was. And the reason why it was inadmissible is because the defendant was trying to introduce this information to prove the matter asserted. And so he was trying to prove that this decedent would drink too much, would fall over. He's using that to prove the truth of the matter. It's hearsay, it's excluded. Does that mean that every time a patient talks to a doctor, it's excluded? Not at all. Because let's say it was a different case, for example, and what was at issue is, why did the doctor treat this patient a certain way? The moment this patient says, I came in, I've got a broken arm, and I broke it skateboarding, that would be admissible not to prove that the person broke his or her arm skateboarding, but if it was to show why the doctor, for example, ordered an x-ray to explain why the doctor acted a certain way, it would be admissible. And so when you look at medical records, you almost want to picture not just the document, but the document being the doctor on the stand testifying to certain things. If he or she is testifying to what was observed, it's admissible. If it's talking about what the patient said, it might be admissible if it's for purposes of understanding the doctor's diagnosis or care that was provided. If it's offered to prove what the truth of what the patient said, it may very well be inadmissible. So that is how to look at medical records. Finally, investigative reports. Now, there can be plenty of types of investigative reports. If we're talking about police reports, some type of governmental entity report, in California, start with Section 1280. That is the public records exception to the hearsay rule. In federal court, we're talking about FRE 8038. But let's talk about investigative reports by a private party. Now, if something event happens where there's an accident and a company makes a report, is that going to be an admissible business record? It depends. And this is where you have to really hone in on the elements. In other words, if there was some accident, when was the report made? Was it made at or near the time of the event? Was it made that day, a day later, 2 weeks later? There's no bright line rule, but again, when you go to the rationale behind the business records exception, what the court wants to look at, is this something trustworthy? And oftentimes, when it comes to investigative reports, there can be a desire to have some self-serving information in there. And so investigative reports can be looked at with suspicion. So those are the types of documents we often see when it comes to business records. I hope this was helpful. If it was, please download, rate, review, subscribe to our Evidence at Trial YouTube channel. And if you want to do a really deep dive and understand these rules and how to turn these rules into weapons in discovery and trial, visit evidenceattrial.com and check out our on-demand courses. Thanks for watching.